Good afternoon, everybody. Today, we're going to talk about something that often brings a smile to my face. I love smiling, so I guess I'm grateful to my clients when they bring this question to me. But we're talking about scenarios most often involving L-1, E-2, sometimes an O-1. And in particular, we're talking about what happens when you sell the controlling stake of your company, or even you sell that company outright. What are the immigration consequences? Good afternoon, everybody. I'm Charles Raether again. And today we're going to do a deep dive into this topic of what are the consequences of selling the controlling stake of your company? What do you have to keep in mind? What are the issues that could come up, and how could this threaten your future immigration status in the US? I'll use the terms E2 and L1 interchangeably throughout this video. For purposes of today's discussion, they're pretty interchangeable. This situation also might apply for an O1 visa, but in principle, O1, sometimes you might own the company that's serving as a sponsor for your O1, but in reality, you don't have to maintain that control for the O1. So sometimes people ask about this in the context of an O1, but it really has no bearing. You don't necessarily need to have a controlling stake in an O1, even if you start off like that with your petition. So for the most part today, we're going to talk about this in the context of an E2, L1, and I'll use those visa names interchangeably throughout the discussion. So today we're talking about that scenario where you sell outright your stake or a controlling stake. And how does that affect your status and or your future? Well, the immediate effect, if you look at the law and everything as how it's written, is the moment you lose control of your company, you're no longer in compliance, and your status should be, and your visa should be canceled as well. Now, the first question is what constitutes control? And that's different for an E2 and an L1. That's the only time in this video where there's a distinction between the two. An L1, generally we tell clients to have 51% because it's just easier. It's easier to prove to the government you have control. If you have 50% in an L1 scenario, you are deemed to have control if we can provide other documentation, usually an operating agreement, a shareholders agreement, maybe proxy, that shows that even though you only have 50, at the end of the day, you have the final word and you can break a tie and your word goes, in terms of controlling the business and stuff like that. So it's possible to show in an L1 that you have control, even with 50%, but it requires extra documentation and it requires the CIS officer to understand what we're writing about. And these guys are not always, the sharpest tools in the shed. So we try to avoid relying on the discrepancy of officers, and we just try to tell clients, look, do 51% and let's go from there. With the E2, you can have as little as 50%, and it's still deemed to have control, even without having any kind of operating agreement or additional documentation to show control. That control by veto, so if your partner can't do anything without you agreeing, that's considered. In the E2, you could have as little as 50%. So in either of these scenarios, whatever percentage you have, to start with 50, 51, 100, at whatever point you lose that control, you technically should lose your visa and your status as of that moment as well. Now, we know the reality is USCIS does not have access to that information. If you sell a stake in your privately held company, that information in most states and most places doesn't go anywhere right then. Most states, I could be wrong, I mean there's 50 states to keep track of, but most states generally don't even keep track of, ownership structures. You're supposed to update the Secretary of State's website, with that information, but in a lot of states, even where you have to indicate the shareholders, you don't indicate the size of their holdings. So the state might not even know about it. Many states, you don't even indicate who the shareholders are. And so, that information is kept secret. So for the federal government to find out about this, it's going to require, either the lapse of a large amount of time or other routes that they would find out. I think the federal government most quickly would find out about this through tax returns. So when you file a tax return for your LLC or your company, you always have to indicate the amount of your shareholdings. And there you would find out, the government would see, okay, you no longer have 51%, for example. But again, tax returns are not filed simultaneously. They might be filed, 6 months, 9 months, 12 months after the fact. So it could be a long time before even a federal agency gets this information. And once they even receive that information, the IRS is tasked with collecting taxes. Their job is not to enforce immigration rules. I don't think IRS would ever even notice and care that, your shareholdings fell below the minimum threshold. And they wouldn't even know necessarily that you're in an E2 status or an L1 status. So for USCIS to find out, the most likely time when they would find out is if and when you go to renew your status or your visa. Now, if you're smart enough or you're working with a lawyer who's smart enough and you know you no longer have control, I can't imagine you would file with the embassy or USCIS for an extension knowing that a priori they would shoot you down because of your lack of control. So I don't think there's ever a case where people file with the government for a renewal and the government says, wait a second, you have only 30%, we're going to deny you. I mean, that would just be stupidity. So I think the only way where the government would find out is, generally speaking, in future applications. So if you clearly know that you're under the 50% threshold, you don't qualify. You don't want to file for renewal if nothing else changes, and you probably just go back to your home country. The risk, though, is that during that time between you lost ownership and when your status or your visa ended, and for the purposes of this discussion, we're talking about status. The government doesn't care if you're living overseas, you lose control, there's no violation there. You're not using the E-2 visa or status to be here. But we're talking about status, that if there's a gap of time between the sale of the business and when you left the U.S., that during that gap of time, technically you were out of compliance. I don't think the government would find out at that stage, with the E-2, you're not going to refile to extend your E-2 because you don't have control anymore. So the government in theory might never not find out, right? Well, yes and no. The government very well could find out later if and when you maybe file for a new E-2 or L-1. Or let's say you file for a green card. Let's say you sold your controlling share because, hey, your wife got a green card. She, had an I-140, got approved, and you guys stayed in the U.S. based on her green card. If and when the government reviews the materials for the green card, the change of status, they very well might go back and look at, say, hey, the husband was here in an E-2 previously, and they could pull up the tax returns and find out, hey, they sold the business at this point in time and they remained here in an E-2 status. I can't say, statistically speaking, there's a high probability of that happening, but the probability of that happening is definitely higher than, if you just stayed here for 2 years after selling the business, went home, and never came back to the U.S. So when they're going to review those green card documents, there is quite a good likelihood that they're going to compare your previous visas, your durations of your stays here, and other compliance issues. We see it on a regular basis in other situations in categories. So I think in this situation, it's quite likely that could come up. Where it could even come up again, and where the consequences would even be more detrimental to you, is if and when you go to file citizenship. So if you go to file citizenship, in 5 years after getting your green card, let's say you get your green card, no questions about your E-2 status, your L-1 status, whatever. When you go through your citizenship, especially under this current administration, they're looking at all compliance issues over the past, all compliance for your visa, your green card, stuff like that. I'm not saying that a majority of cases get reviewed for this issue and they're going to check for compliance with the E-2 and did you always have control. I'm not saying that the majority of cases are getting reviewed like that, but the likelihood is then with a green card, which is higher than if you just left after a year or two when your E-2 expired. So each step of the stairs that you ascend on is more likely to lead to a situation where they might compare things looking back, and the consequences for you are much worse, right? If you get an E-2, you leave after the end of that E-2, you never come back to the U.S., and they say, oh, bad person, slap on the wrist, we're not going to give you any more visas. Okay, maybe it's not a big deal. But if you're filing for citizenship and you're that close to doing it, and they look back 5 years ago, 10 years ago, you were out of compliance, that can be a really serious problem. So the short answer is you just always want to stay in compliance. Some cases, the consequences would not be that great, and the likelihood could be very small, but the longer you spend in the U.S. and the further you proceed with the immigration process of getting permanent residency or even citizenship, the more serious the detrimental consequences could become. So you really want to avoid that. So in closing, hopefully this was of benefit for you, just to make sure you're aware of some of the possible roadblocks and challenges that might approach you if you're looking at selling a portion or all of your business. At the end of the day, just careful planning with an experienced attorney is the best way to avoid any problems, even in the unlikely event that they would arise. But given the stakes that are at hand, especially if you're progressing to a green card and even citizenship, you need to be ever more careful about maintaining compliance with your previous visa statuses to avoid any issues. If this sounds like something that you're considering or you might have encountered already and need some assistance, please reach out to us. We're here, always ready to assist you to make your transition to the U.S. as comfortable as possible.